Good morning. This is almost early afternoon now. It's wonderful to see you all here. I'm going to talk a little bit about special needs trusts, guardianships, and powers of attorney, and some of the different options that exist for families who have family members or children with disabilities. I'm not real tech savvy, so if I pause here, I'm trying to figure out how to change the slides. So most of my clients, when they come into the office, their biggest fear is what happens to my family member that has a disability or a special needs when I'm gone. That's the biggest concern. How can we make sure that they're taken care of? And that's not just in a financial aspect, that is in a care aspect. It's in a, where are they going to live? Who's going to take care of them on a day-to-day basis? Who's going to make sure that the facility is doing what they're supposed to do? Who's going to check up on them? Now, nobody's going to do it like mom and dad. We know that. But what we'll try to do is put a team in place to help facilitate that today, tomorrow, and in 20, 50 years. So that is the client's biggest concern when they come into our office. And part of that starts with planning. So if you can plan, you can do as much as you can. That's what I would always recommend to you. Plan early, start early, reevaluate your plan every couple of years, and make sure that it still fits the needs of your family and you. So most people don't have the planning in place. 62% of parents have no plan. They don't have wills, they don't have special needs trusts. And a lot of that is because most people they don't know about it. They don't know what a special needs trust is. They don't know what options exist for their children or family members. A lot of parents don't have life insurance. And a lot of times life insurance is what funds these special needs trusts to help take care of these children when they're no longer around. So typically, what do? If they don't have planning, we see 50% of them leave money directly to the child with special needs. And I'm sure that most of you in the room know that if someone is on Medicaid and they receive a large sum of money, they're not going to be on Medicaid for very long. They're going to get that lovely 30-day letter, and then their benefits are going to discontinue. Now, if it's enough money that they don't need the benefits anymore, that's wonderful, but typically that's not the case. So it won't care for them forever, whatever amount of money that is. So you have to do some planning as to what you're going to do with that money. Some people will disinherit their children. There's a few different options that we see. I don't recommend it. So what they'll do, they'll disinherit their child and say, I have 3 kids, one of them has a disability. I'm going to give this money to my other 2 children, and they'll take care of them. Well, it's a great idea in theory until older sister Susie marries a guy who's bankrupt, and now all of that money is gone, or they start a business, then it fails, and this poor individual with the disability is left with no money to care for them. Sometimes they will transfer it to other family members, whether it's grandparents or other individuals. It never works. It's not a good idea. The best way to plan is to do a special needs trust. There are 2 types of special needs trusts, and I'll just briefly go over what they are. There's something called a first-party special needs trust. First-party special needs trust is designed to protect benefits for an individual who has money. Typically, this money is something that is inherited if there is no special needs trust already in place, so it comes into their possession, or from litigation proceeds, personal injury settlements, medical malpractice. So that's a first-party special needs trust. The major difference between a first-party special needs trust and a third-party special needs trust is that a first-party special needs trust has a payback provision. What this means is that Medicaid allows you to qualify for benefits and have this trust in existence, but they essentially run a tab for this individual's lifetime. And at their passing, Medicaid says, okay, you've utilized $100,000 worth of benefits since this trust was established, and we would like to get paid back up to the full amount of our lien before money is paid out to anyone else. So it's not something that a lot of people like to hear, because they would like this money to go out to other family members or through the estate of the individual, but It is advantageous in that if you've got an individual who has 16 hours a day of nursing, that's probably out-of-pocket cost, $400,000 to $500,000 a year, and most trusts can't support that type of cost. So Medicaid can pay for that nursing while this person is living for as many years as they need it, and then the trust can pay for the supplemental needs. It can pay for the vacation. It can pay for the housing modifications. It can pay to enrich this person's life. And so if the lien is larger than the trust, that's okay. All they do is take up to the full amount of the trust. They don't seek recovery from family members. But the Department of Public Welfare and Social Security do look at the distributions to make sure that the rules have been followed, because they don't want to see gifting here, gifting there, hiding money, because they always find it. So the third-party special needs trust is designed for individuals who typically inherit money or are given money by other individuals. So you'll typically see a family that has one third-party special needs trust, and everybody leaves money to that trust. So you've got parents and grandparents and aunts and uncles. Anybody can leave money to this trust for this individual. There is no payback provision in a third-party special needs trust. So you do not have the oversight that you would in a first-party trust. Third-party trusts are a little bit more flexible, still have the same rules, but there's just a little less oversight. So it works very well for people. Of course, the main reason you want a special needs trust is because you can continue to keep your benefits. And I know recently in the last year or so, DDD has required that the individuals to receive services be Medicaid eligible. And we've seen a lot of clients come into our office wanting help because they need to have their family member qualify for Medicaid, and maybe they were on the cusp or they were doing fine and really didn't need this nursing type care that we talk about, but they were in DDD services, which are very important. And so we've had a lot of families come in, and we're trying to do some planning for them to make sure that they can qualify for Medicaid now that they're having these rule changes. Other public benefits that people utilize and can utilize when they have a special needs trust are listed above. I won't go through all of them. Most important too, I would think, are the Social Security and the Medicaid. You can receive food stamps, Section 8 housing. Each one of those organizations have their own rules in terms of special needs trusts and distributions thereof. And in a little bit, I will give you my 2 cents as far as why I think you need a good trustee, but it's reasons like this that you want to make sure that somebody has an understanding so that you can continue the benefits for the individual, because I'm sure everyone in this room works very hard to make sure that their family member has these public benefits they need, whether it's the waivers that Joe has been discussing, and we all know they're shrinking. So everybody wants to keep their waiver if they're in one. The main features of a special needs trust is that the assets are not available for that individual. So that's what allows them to qualify for public benefits. So there may be $100,000 or $1 million in a trust, but the government doesn't see that as an asset. They see that as a totally separate being, so that this individual can qualify for Medicaid, Social Security, or other public benefits. Distributions from the trust are not deemed as income. If done appropriately from the trust, they're not income to the beneficiary. Now, you cannot distribute money from the trust to the disabled beneficiary because that is income. But there are ways around that. Typically what we recommend to our clients, and every situation is very different, you can get what we call a trust credit card. It's a regular credit card, and it's used only for that person's benefit for items that Medicaid and public benefits don't pay for. So clothing, you go to CVS, you need certain items, certain medications like Tylenol, things that Medicaid's not paying for. Then you put that on the trust credit card. The trustee pays that every month, and that's not income. So it's a very small difference in the way that the funds are paid out, but it makes a very big difference in that the individual can still qualify for benefits. And again, as I'm going through this, if you have questions, I'm happy to answer them. And afterwards, I'll try to leave a little bit of time so you can ask questions. So we do recommend that people do the trust credit card. That's a great way to do it. The other part of it is that you can reimburse someone. There has been a little back and forth with reimbursing family members. Social Security made a few changes last spring. This was spring a year ago, saying that they did not want family members reimbursed, that was actually going to be income to the beneficiary. They have pulled back on that for now. My law firm is part of something called the Special Needs Alliance, which is a team of attorneys. There's one in every state that does exactly what we do. And when these rules came out, they were a massive hindrance to our clients. And so the Special Needs Alliance went down to Washington and lobbied for some changes. And so since then, they have pulled back. They have changed many of the people high up in the administration of the organization, and we're working with them to facilitate some rules that make more sense. Because not every family can get a credit card. Unfortunately, we have families that, don't have good credit or don't have much income, and so they can't qualify for a credit card. A lot of times the corporate fiduciaries or trustees can help them, but it's not always the case. And we also have situations that there's no choice but to reimburse the family member. And so we have been trying to find better ways to make this work for families. You can do a trust that's funded today. You can do a trust that's funded in 10 years. So one of these words means during life, and the other one means at passing. Many individuals that have a family member with a disability fund these trusts at their passing. So they take care of their family member while they're living, and they fund the trust when they pass away. And that would be this third-party special needs trust. Again, we'll call it the inheritance special needs trust. And typically, the documents are irrevocable. There are ways to revoke them, but only for good reason and usually with court involvement. So the government wants to see a complete removal of the money from the disabled beneficiaries so that they're not deemed to have those assets, and those are the reasons why you have to. So in my former life, I was a trustee. I ran a special needs trust department at a corporate trustee locally before I joined Bagley. And so I understand what it is to administer these trusts on a daily basis. I was on the ground level with the families as they're getting waivers, as they're trying to weave their way through home modifications. So when I draft a trust, my goal is to make the trust work, most importantly for the beneficiary, but to help the trustee do their job so that they can help the beneficiary as much as possible. So I'm very picky about who I recommend as trustees because I know many of them and I know what it means to be a good trustee. First and foremost, I think you want to have a trustee that cares about their beneficiaries. They should meet them, they should know them, they should know the families, they should know the dynamic, and most importantly, they should know the care plan. Because if something happens to you, they need to be able to step in because they're the closest. Of course, they're not a family member, but they are controlling the money. And that can be helpful, and they have resources. They have a Rolodex of people that they can get on the phone with and that they can help you. And so I always recommend somebody that's personable and that will get involved in your life to the extent that you want the help. Some families don't need the help, don't want the help, but others can really use it and say, you know what, I need to put in a new ramp. Can you help me find somebody that will do it at a reasonable price and do a good job? And they have a list of people that they work with because we typically see a lot of situations where people hear the word trust and the price goes up 30%. And that's not what we want. We want them to be able to get the best price and the most fair work done. So that's one of the reasons why I think the trustee is one of the most important things that you can do. When you're looking at establishing these trusts, make sure you have a trustee that you're comfortable with. I recommend that you meet them or talk to them on the phone before you name them, because the worst case scenario is that now you're involved in this 10 years down the road, something happens to you and you have a trustee that isn't involved in the life and can't step in and help and can't be part of that advocacy team for your family member. So you need someone that understands public benefits. The most important part of these special needs trusts is to maintain public benefits. So if they are uncertain of the rules, aren't up to date on Social Security rules because they change quite frequently these days, then they make a distribution, your family member can lose their waiver. And again, we talked about earlier how difficult that can be. So you want to make sure that they know exactly what distributions are appropriate and which ones aren't. And if you need something, how can they do that? What is a way around this? How can we tackle this problem and allow this person to maintain their eligibility? They need to understand taxes. These trusts are taxed at a different level. They need to understand how that affects families. If a child comes into money or has a special needs trust, they need to understand that there's an informational return that's filed for the trust every year. They need to keep perfect records. More and more often, we are seeing these government benefit agencies saying, we want to see exactly where the money's going. They can audit these accounts at any time. And so what they will do, they'll say, give me all the statements. Okay. They look at all the statements, and then they'll see, now I want to see all the receipts. I know that you went to CVS on December 21st. I want to know what you bought. And it seems ridiculous, but they do it, and they are doing it more and more often. They want to make sure that you bought only toothpaste for the disabled beneficiary and not for the household. I mean, it is little minutia like this. And the trustees are generally very good about making an understanding and keeping those records so that it is not a 2-year headache with these agencies, because typically then legal counsel has to get involved. Everything gets more expensive, and it's unnerving for people if you get these letters. And so you want someone that can help you through that process if that happens. You want them to be insured. You want to make sure that the person that is in charge of this individual's money is insured and that they're not going to run off with the money to Atlantic City. You need to make sure that there's money available to recover if something happens. You want to make sure that they understand professional investments. You want to make sure it's not going into a hedge fund. You want to make sure that it's excuse me, that it's done in the best way possible to allow the account to grow, but be conservative and safe. There are statutory requirements about how the money should be invested. All trustees do not follow them. The good ones do. The good ones understand this is the individual's age, this is their situation, this is how I think the money should be invested. Typically they're on target, and they take direction from the family. And again, this is why you want them involved. This is why you want them to know who you are, who the beneficiary is. Possible trustees include disability organizations. There's local disability organizations and nonprofits that will administer these trusts. They have what we call a pooled trust, which is typically for smaller trusts, and it's usually $25,000 to maybe $100,000 that they will administer. It's pooled for investment purposes, but the trustee the individual has their own account. So that is one of the options. A bank is another option. Again, some banks do it, some do it well. So be cautious about where you're going. Make sure that they have individuals who are experienced with trust administration for special needs trust, because this is not great-grandfather's oil money going down to the kids. That's not this type of trust. It is a completely different type. And so some of these high net worth money managers say, oh yeah, we can take care of it, no problem. It's not the case. We usually see them getting removed 6 months to a year later. You can have a family member do it. For smaller trusts, I think it's okay. If they're larger, I don't recommend it. And the reason being, it's onerous to the family member. There's record keeping, there's taxes, and there's Social Security and Medicaid rules that need to be followed. And most people don't understand them. I mean, I wouldn't if I didn't do it for a living. So sometimes it's a good idea, sometimes it's not. In the state of Pennsylvania, if there are litigation proceeds that are more than $25,000, the court requires a trust and requires that a corporate fiduciary administer that trust. They will not allow the family member to administer it. You can also have co-trustees. Parents can be co-trustees with the bank if they're uncomfortable with the bank being the sole trustee, and I understand that it can be a relinquishing of control to have a bank be the primary trustee. I have never had a poor experience with it. Some parents feel better if they're a co-trustee. What we typically do in our documents, we always give the parents or a family member the right to fire the trustee, so you are never stuck. It may be that you just don't like the trust officer, that you don't get along with them, the personalities don't click, they don't understand your situation, which happens, or it may be that you really just don't like the organization and that you don't like their investments, you don't like the way that they're transforming. You can always remove them. You always have the right to fire the trustee.
Kristen, if you are for a guardian from another state and you move to this state, did your guardianship go with you, or do you have to get a new guardianship?
There is a new statute in Pennsylvania. Well, you can do two things. You can transfer the guardianship completely, so you have to get it removed. Thank you so much. You can have it moved to Pennsylvania. So you go to New York and say, I'm moving to Pennsylvania, I'm going to transfer my guardianship. They allow you to do that. You then go into court in Pennsylvania and tell them that you are bringing the guardianship to Pennsylvania. You essentially do the proceedings over again. The other option is to file it with Pennsylvania, and you have them they will identify the document. So they will give you the powers in Pennsylvania that New York gave you. Now, for some states, that works very well. So, for instance, in New Jersey, guardianship orders are extraordinarily restrictive. They give you certain powers and certain specific things that you can do, and you have to get court permission otherwise. Pennsylvania, they're very broad orders. So to take a Pennsylvania order somewhere else is an easy thing to do. To take a New Jersey order and have it recognized in Pennsylvania, you still have the restrictions. Depending on what the order says, it might make sense. It's certainly less expensive to just have it identified in Pennsylvania and give you the powers in Pennsylvania that you had in New York. Okay. Excuse me, I don't know what this cough is about. When you're funding a trust, we like to look at a life care plan if one has been done. If you don't know what a life care plan is, it is a document done typically by a nurse case manager who lays out the individual's needs, the future plan, and it really gives a good idea as to what this individual's situation is. There are a few calculators that are used to project the cost of this individual living once the family members are deceased. Some are more accurate than others. Some of them you punch in the numbers and it's going to tell you that you need $45 million to take care of your child, and it's probably not accurate. Maybe sometimes it is, but so take them at face value. Some people call and say, I just went into the MetLife calculator and I don't have 50 million. And it's okay. We'll find another way to do it. The other item that we really recommend that our clients do, and we have a template for it, is what we call a letter of intent. And it lays out everything about your family member, from what their favorite television shows are, what time they take their medication, who their best friends are, who's the best person to call in an emergency if they're upset about getting on the school bus, who's the best person to call if they can't sleep. What do we do? How do we get them to sleep every night? And this letter for parents usually takes them a very long time to do it, but they write down exactly what their child is like or their family member. And it helps them pass on a little bit of as much as they can, because certainly nobody's going to take care of them like you will. But you can certainly try to give everybody as much information as you can. Wrapping up here, the counseling session, we typically always have a trustee. If we can, we have you meet with the trustee. We're there. We talk about how long the trust is going to last, given the expenses of the trust. Child turns 18. Most of you here, I'm sure, understand there's a guardianship or a power of attorney that generally needs to be done. If you can do a power of attorney, I think it's a great thing. Obviously, the individual needs to be competent to sign a power of attorney. And we can either have a doctor do the evaluation, or we can talk to them and assess whether they understand what they're signing. If they can, it's wonderful. It's less expensive, it's less time consuming, and it really gives you pretty much the same powers. Guardianship is what needs to be done if the individual does not have the capacity to understand what a power of attorney is. It's a process through the court. The doctors certify that the individual is what we call incapacitated. Go in front of the court. The disabled beneficiary is there, and the judge makes the final call. But typically, it's not a quick process. It's about 90 days, depending on the court and depending on what county you're in. The guardianship, of course, is the most restrictive, so that's why we recommend a power of attorney if you can do it. The guardianship does take away most of the individual's legal rights, so we always make sure that if it's necessary, we do it, but if we can do it in another way. The final piece of the puzzle is estate planning documents. Everybody thinks about what they need to do for their children, but they don't always think about what they need to do for themselves. A will is very important. A will is especially important if you have a special needs trust, because that will has to leave the money to the third-party special needs trust. So you also need a living will, you need medical power of attorney, you need general power of attorney. All important items that you should not forget about yourself, okay? So that's all I have. I think I'm out of time. Thank you so much, guys. You were a wonderful audience.